Hello and welcome back. Today we're looking at an analysis of the complex legal arguments and specifically the recent judicial order in that lawsuit alleging social media platforms like TikTok harm youth mental health. It focuses particularly on that discovery dispute involving Eugenia Cooney.
Right, a really dense topic.
Absolutely. And overall, the depth of the document review in the source material is, well, it's outstanding. It's clear a lot of time went into accessing and really synthesizing the nuances of those joint letter briefs and, Judge Kang's order from October 20th.
It's heavy stuff, legally speaking.
It is, but our first major area for improvement really circles around flow and presentation structure. Basically, the structural flow and the authority of the piece get a bit compromised by these sort of lengthy, unintegrated segments of personal announcements.
Yeah, and self-promotion.
Exactly.
They abruptly halt the detailed discussion of these complex legal filings.
That's the crucial point, I think. The listener's trying to track this really dense, high-stakes legal content. We're talking the specifics of the plaintiff's corrected joint letter brief where they're fighting for, 300 more specific documents on Cooney?
That's right, a huge number.
And that focus just gets repeatedly broken. You have small things like pausing to define a word like ongoing, which maybe isn't necessary for this audio, or mentioning the drink.
The kombucha moment.
Right.
Yeah, but the really big one is the book announcement. It just drops in there. The transition to talking about the debut novel feels really abrupt, like right after summarizing a key legal point about compelled documents.
Okay.
It kind of deflates the whole analytical buildup.
I can definitely see how that would yank the listener right out of that legal mindset. If you're deep into the MDL intricacies, you need to stay there. So the suggestion here is pretty straightforward. Implement clear structural segmentation. Meaning we need to make sure the full legal review and analysis are totally completed, like properly wrapped up, before pivoting to any personal updates or promotion. The core analysis needs that uninterrupted focus, especially right through the discussion of the judge's order.
Okay, so making that actionable. It sounds like you need to completely isolate that whole segment about the new novel. And look, the enthusiasm came through. It's great news. Dark fantasy, bound by blood and sea, gay mermaids, Irish mythology, November 16th release, 900 pre-orders. That's genuinely fantastic.
It really is.
But that passionate, detailed breakdown just can't be woven into the main legal analysis like that.
Right. That level of detail, that excitement, it really belongs somewhere else. Maybe a dedicated segment at the very, very end. Make it optional or keep it strictly to the intro or outro remarks.
Yeah. Keep it contained.
It's about protecting the integrity of the objective analysis, giving the legal discussion the kind of focused, respectful space it demands.
Makes sense. Okay, moving on from structure, let's talk about the analytical stance. The piece states the goal is to be a neutral third party, which is, vital when you're dissecting these really contentious legal fights.
Absolutely critical.
But the credibility sometimes wavers a bit because that neutrality isn't always consistently maintained. You get this kind of unpredictable blend of reporting legal facts and then offering quite definitive personal judgments.
Ah, I see. So the weakness there is, as I read it, the creator inserts these pretty firm declarative personal opinions, moral judgments, instead of framing them maybe as strategic hypotheses or analytical questions.
Can you give an example?
Sure, like declaring the request for documents unreasonable, without maybe fully unpacking the legal basis for why it might be seen that way, or just stating flatly, I don't agree with TikTok's legal argument about timeliness.
Right. Or the comments about platforms being purposefully addictive. That's a strong personal belief injected in there.
Exactly. And it creates this difficult oscillation for the listener, especially an expert audience. They're tuning in for strategic insight, right? Into the judge's thinking, the party's moves. When strong personal opinions get mixed in so definitively, it becomes hard to tell where the impartial summary of the judicial view ends and where the host's own commentary begins, which is tricky territory with sensitive subjects.
So the suggestion?
It's about refining that approach. Maintain like a purely objective tone when you're summarizing the legal positions, plaintiff, defendant, Judge Kang's actual order. Then when offering independent analysis, use more constructively skeptical phrasing. Think questions, not declarations.
Okay.
That way, it appeals to that expert audience looking for strategic insight, not just, validation of a particular moral stance against social media.
Let's drill down on the language maybe. Like when discussing TikTok's rebuttal, that argument they made about the plaintiff's selected images of Cooney being in poor taste or exploitative, the reaction in the piece was very immediate, sort of personal. Something like, They kind of clocked him with that one.
Yeah, that's a strong, kind of emotionally charged take. Instead, you could rephrase it to provoke strategic thought. Ask something like, what's the strategic legal effect here of the defense using a moral argument about exploitation to try and deflect the plaintiff's main claim about TikTok's willful complicity?
Okay. Like, does that tactic actually work to shift a jury's focus?
Precisely. Or take the discussion about the discovery deadline. Instead of just stating that the plaintiff's request regarding the May 2025 collapse was not unreasonable, frame it as a challenge to the legal framework itself.
How so?
What precedent gets set if the court accepts this argument, that new information, like a major event like the May 2025 collapse, can override an existing discovery deadline? In this case, the deadline was April 4th, 2025.
Right, so it turns a personal opinion into a much more sophisticated question about legal strategy and potential ripple effects.
Exactly. That elevation in tone really aligns with the expertise level you're aiming for. Now, that brings us nicely to the concluding analysis of the judicial order itself, because this is where I think the biggest strategic opportunity lies.
Okay.
The overall assessment about denying the broad requests, protecting creator privacy, the judge doing that, it's astute. But there's a chance here to really maximize the so what of the limited discovery ruling.
The part they did win?
Precisely. The conclusion needs to much more immediately and forcefully spell out the specific strategic value of those limited documents the judge did compel TikTok to produce.
I completely agree with that. The current conclusion focuses maybe too much on why denying the deposition of Cooney, who's a third party, remember, and denying access to documents not related to May, like the search block history, why that was the right call.
Right. It spends time justifying the judge's ruling based on creator privacy, maybe mentioning GDPR, avoiding making creators culpable.
Which, okay, it's relevant context, but it totally overshadows the actual tactical win for the plaintiffs here. It buries the lead almost.
That's the key pivot needed. Move quickly from summarizing what the plaintiffs didn't get to emphasizing the really sharp strategic significance of that narrow production order. What exactly are they now legally allowed to see? That's the payoff.
Especially for an audience following this MDL closely.
Definitely. Think about the underlying drama of it. The court says no to the big splashy requests, but then quietly hands the plaintiffs potentially the exact evidence they need to test their theory of corporate knowledge.
So the emphasis should be on Judge Kang's order requiring TikTok to do a reasonable search due November 10th, 2025, right? For documents directly tied to those two crucial May 2025 events?
Yes. And we have to specify what those two areas are. This is the money shot. First, TikTok has to produce internal communications and analysis about that May 23rd live stream. Specifically, documents testing if it was flagged internally.
Flagged as problematic or impacting youth users' safety.
Exactly. And second?
Second, documents about any inquiries, media, government, users related to that stream, and the internal communications that followed. Like, how did they decide to talk about the collapse event? Did they bring in PR firms, crisis management?
Right. And these compelled documents are just hugely significant because they directly test the plaintiff's core hypothesis. Was TikTok aware of potential harm, and did they act complacently, maybe even continuing to promote the creator despite that awareness?
It shifts the whole focus, doesn't it? Away from just whether the creator's content was problematic.
Which isn't really the core legal question for TikTok's liability.
And onto the crucial question. What did TikTok's internal teams, their executives, know about specific harms, and what did they do or fail to do with that corporate knowledge?
That strategic significance has got to be the final powerful takeaway because it goes straight to the heart of the MDL claims.
Yeah, that lands with much more impact. Makes the conclusion really relevant.
Okay, so this has been a pretty robust review of some seriously complex material. Just to summarize, we focused on three main areas for improvement. First, enhancing structure. Segmenting out personal content to keep the core legal analysis clean.
Right. Protect its integrity.
Second, maintaining that analytical rigor, really separating personal beliefs from objective legal summaries and analysis, using questions.
Keeping that neutral stance consistent.
And finally, maximizing the strategic importance of the narrow discovery ruling right at the end, focusing immediately on the specific internal documents TikTok now has to produce.
And if you're revising,
I'd say the single most actionable thing is to really center that post-ruling analysis on those internal communications and safety analyses TikTok has to disclose about May 25th, 25. Because that's the direct path to potentially proving corporate knowledge. And for your audience, that's probably the highest value insight you can offer right now.
Excellent point. Well, we hope this feedback helps you refine the presentation, really maximize its impact and authority. We definitely encourage you to implement these suggestions and, feel free to submit the revised material back for another look.
Absolutely.
Until next time.